Who is this guy, and what exactly does he want to sever? And before I go on, this is Tony DeWitt, the appellate lawyer from Missouri, and I'm here to answer your questions and hopefully tell you things you didn't know. Well, folks, it sounds like YouTube no longer wants to have little clips that are introductions to your channel, so I'm going to dispense with the little thing that I had in there before about good questions and good answers and that thing. And I'm just going to go straight to the content. If anybody has any comments or questions about that, let me know, but it just is designed to try and make this a little bit easier to comply with YouTube's newer guidelines, which change about every 3 days, it sounds like, but not really. So, I've often said, and I say it all the time on this channel, that trials are not won in the courtroom on the day of trial. Trials are won before you ever get to trial, in depositions, in discovery, and in motions practice. Now, motions practice is where you take up issues throughout the course of the case in order to get them decided so that you know what path you're going to take. A lot of times there might be 3 or 4 different avenues you could pursue, and as things get discovered, as issues arise, as defenses are raised, or as new theories of liability are raised, you have to adapt and change to that. And of course, the way that you get anywhere in this system is to be able to adapt and change with the changes that come up in the case. So today we're looking at Alex Murdaugh's boat case, or I should say Mark Tinsley's boat case involving Alex Murdaugh. Now there are 2 motions at issue here in this case, in this hearing. The first is a motion to sever, or a motion for severance. And what severance means is that the case against one party will be tried separately from the case against the other party. And there are reasons why you do that and reasons why you do not do that. And the law in South Carolina seems to be pretty clear. So let's take a look first at the motion for severance, and then we'll take a look at the second motion, which is a motion for the change of venue. Now, just to sort of give you a little bit of the background here, here is a real quick overview of what's going on and why this motion to sever has been filed. You have the Murdaughs over here on the left side and Parker's over here on the right. Parker's is the institution that sold Paul Murdaugh the alcohol. So the parties originally, when this case was filed, was Paul Murdaugh. Of course, his estate was later substituted. Alex Murdaugh, the boat owner. Buster Murdaugh, because he gave Paul his driver's license to buy booze. And Maggie Murdaugh, because either she was co-boat owner or because they thought perhaps that Alex might have hidden some of his assets inside Maggie Murdaugh's accounts. So the way the case currently stands is Paul Murdaugh has been dismissed and Buster Murdaugh has been dismissed because he paid money. Paul didn't have any assets. Buster paid some money to be dismissed. And Maggie Murdaugh is out of it, I think, again, because they didn't find any hidden assets or they couldn't tether the liability directly to Maggie. So then that leaves Alex Murdaugh and Parker's as the only 2 defendants left in this case. So what does that mean? Well, in terms of prejudice, it means that some of the animosity toward one or both might bleed over on the other. So it could be that people are going to look at this case and they're going to put all the blame on Alex Murdaugh for having let him use the boat. He let Paul use the boat that night. So they could very well place all the blame on him and much less blame on Parker's because they sold the alcohol. But you have to remember that Alex has his own set of problems. He's still not through with his criminal cases. And as a result of that, he's probably going to be paying his lawyers until he's dead. So then you have Parker's, and they are the people who sold the alcohol. And the fact of the matter is that there's probably a good chance that the jury is going to realize that if they're going to do anything for the Beach family, that they're going to have to get money out of Parker's because Alex isn't going to have any, and a judgment against him is pretty much an empty judgment. Okay, so in this first clip that we're going to look at here, the lawyer for Parker's is going to do something that I have seen very few people ever do, because generally speaking, it's not a very successful strategy. Originally, he filed a motion to sever, and it was granted. Mark Tinsley filed a motion to reconsider. The judge did reconsider and realized he was going against 200 years of settled precedent. And as a result, he reversed himself. But now, watch how the lawyer uses the original order to sort of impeach the judge on this issue. We'll have to see how this works for him.
And if there was ever a case in which a court may exercise its sound discretion to order separate trials to prevent delays or prejudice, this is it.
All right, let's talk about that. Now next, Parker's lawyer is going to set out his basic justification for why the court should sever this case. Even though he's already reversed himself once on this, he's still going to get his basis into the record, if for no other reason that he might want to appeal later on. Let's listen.
The media frenzy surrounding Alec Murdaugh and his murder conviction has gone beyond South Carolina, beyond the Southeast. It's gone national and global. The plaintiff has settled and dismissed everyone else. They just recently, as the court just heard, are now dismissing without prejudice the estate of Paul Murdaugh, who was driving the boat that ultimately killed Mallory Beach on that tragic night. And so we sit here now with Parker's and Alec Murdaugh as the remaining co-defendants in this matter. The prejudice, Your Honor, that was present at the time that this court, we believe, appropriately severed the case, so severed Parker's away from the Murdaughs, is still present. It's worse. And more importantly, with all these dismissals, it's more concentrated, Your Honor.
Okay. Well, before the judge hears from Mark Tinsley, he sort of reminds our lawyer here what the state of play is. I think you'll find this rather interesting. Let's watch.
Let me be sure the record is clear. That is a motion, that is an order that I heard a motion to reconsider on. I looked further at the law and the motion and everything that had been filed in that case and the facts of the case, and I did. That's fine with you to keep referring to the order.
Yes, sir.
But the court reversed its ruling and did not sever the case.
Correct.
Right,
Well played, Judge. Well played. So after Parker's lawyer got through, then Mark Tinsley was able to get up and very briefly lay out the entire theory for why this case should not be severed, and did it in a much more persuasive way, and in my opinion, than did the lawyer for Parker's. Let's listen now.
I suspect no one's ever quoted Pee Wee Gaskins to you before, but I'm going to quote him now. Fairness and justice are dependent on your perspective of whether you're giving it or you're getting it. And if you look at, I'm not going to go back through our whole motion to reconsider. In the brief, I extensively briefed everything he's just talked about, but I'm going to point out a few things. You can't come in to a situation, a case, pour gasoline on something, set it on fire, step back, and then claim that you have unclean hands. In the motion to disqualify me, I filed with Your Honor the blog, the 28-page blog that Greg Parker's employee filed and made public in July of 2021, after the murders, containing inside information only available to the lawyers. Mr. Parker has sat with the Wall Street Journal. He sought the Wall Street Journal out to make this subject the focus of worldwide attention. He sat with Dateline. He sought them out. He sat with Netflix. He sought them out to give his statement. To the extent that they argue there's some change in circumstances and they have unclean hands and all this attention, the facts don't support that, Your Honor, and there's no evidence in front of you that would support that conclusion. And that's really the point. If you look at, for instance, Smith versus Tiffany, every single case that's cited in the brief before where a defendant claims that the 200 years of settled law in this state, that the plaintiff is the architect of her complaint, of her case, of how she presents her case when it's an indivisible injury, like a death, and common issues of questions of law and fact, and they are in fact that she gets to decide. She is the architect. In every one of those cases, the Supreme Court has addressed this idea that there's some unfairness. We have a system that encourages the resolution of lawsuits. They have the keys to the jail.
Well, now, you're probably wondering why Alec Murdaugh's lawyer isn't chiming in here and offering his opinion on this motion to sever. And that's because his lawyer has not arrived yet. He set that up in advance with the court so the court would know. We will hear from him in a minute. But I thought that was a pretty good answer to the rather long and especially long-winded argument that was made on the motion to sever by Parker's attorney. We'll find out how that ends here in just a second, but now let's take a look at this issue of a change of venue. You get a change of venue when a jury can't be impaneled in the area. Now, a lot of people mistakenly think that that means you have to impanel a jury that doesn't know anything about the case, and of course that's not the rule. What you have to have is a group of people who can come into the courtroom, put aside what they've heard in the media, and make a determination on the basis of the information that's presented in the courtroom. In other words, whether they care anything at all about Alex Murdaugh or not, whether they heard the murder trial or not, whether they have opinions on the murder trial or not, doesn't matter. What matters is whether they can come into the courtroom and say, okay, yeah, I know a few things about it, and yeah, I have some opinions, but mostly about the murder case. I don't have any opinions about the boat case. And so, yeah, I can listen to what the evidence is and I can make a determination based on the evidence. Well, then you can impanel a jury. So let's listen briefly to what Parker's lawyer says the issues are.
As I mentioned, the motion to sever and the basis for the motion to sever are also somewhat intertwined and overlapped with the motion to transfer, Your Honor. Under South Carolina Code 15-7-100 A2, we recognize that this is in the discretion of the court. Your Honor may be familiar that originally there was a motion to transfer in January of 2020. That motion was based on convenience of witnesses. This motion, as Your Honor is aware, is for prong 2, which talks about the ability to get a fair and impartial trial. So it's different from the first one. I think some people have said, well, you filed it before. What's different? But it's a different motion, Your Honor, as you know. Your Honor, per that rule, you have to get an affidavit from a Hampton County resident to say that they believe that you cannot get a fair and impartial trial here. And that's not easy to do. We were able to get 2. I understand that Mr. Tinsley just this morning, right before the hearing, has something to suggest that one of the folks who gave an affidavit, Ms. Brown, may not have property here in Hampton County. She reported that she lives here part of the time, but more importantly, Your Honor, we have the affidavit of Mr. Rant, who's been a resident of Hampton County for 60 years. And the point of the affidavit is not to go and talk to every single resident of Hampton County, because there's a lot of people who don't even want to talk about this. But the affidavit gives you the ability to at least file the motion, which is what we've done. Your Honor, we do believe that the notoriety, I was talking about jury selection. Now, again, in this case, in this county, we know the Murdaugh name has influence. Everybody's going to have an opinion, one way or the other, whether it's good or bad. But there is an opinion. And again, Your Honor, it would be one thing if we're talking about a breach of contract case here and the Murdaughs may be involved. We are talking about Alec Murdaugh, who practiced law here, had a firm here, who is now convicted of killing his wife and his son.
Parker's lawyer had to do here was two things. One, he had to lay out the factual basis for why he was moving to transfer venue, and two, he had to provide some evidentiary support. Now, usually, although judges don't necessarily always read them, you want to have more affidavits than fewer. The idea that you would just go out and get 2 affidavits, that's sort of a throwaway. It's sort of like, yeah, we're filing this motion, but we're not really serious about it. What you would need to do also is you would need to have affidavits that gave specific reasons for why people felt the way they felt. I would have gone out and got affidavits that said if it wasn't for Parker selling this alcohol, Maggie and Paul would still be alive. And I would have done other things to show that the people in that county were specifically prejudiced against my client. Now here, what they're doing is they're saying they generally know the facts of the case and they don't believe you could get a fair trial, but one of them isn't even from that county. They were just up there visiting. I mean, you could go to the internet and get thousands of affidavits like that if you wanted them, but all that would prove is that there's no place to go get a fair trial. So let's see what Mark Tinsley does with respect to this in terms of how he handles the issue of perhaps whether there should be a change of venue or a transfer of venue here. Let's listen.
Judge, Mr. Scheer says that the rule requires an affidavit. The rule, the law, the Constitution require a formidable showing, a showing that it is truly impossible. This is Alston versus Black River Electric Co-op, 345, South Carolina, 323, South Carolina Supreme Court opinion from 2001. It's truly impossible to strike a jury in which the jurors, the venire, will either say that they will follow the law, say that they will abide by their oath, and follow Your Honor's instruction. An affidavit, he says, in the fill-in-the-blank affidavit they got from, he said Mr. Rant, it's Gerald Brandt. I know Mr. Brandt. Even if you were to consider this affidavit, and let me jump back to Ms. Brown. Ms. Brown, in the fill-in-the-blank affidavit, it says that she's a resident, because that's what Mr. Scheer wrote on it. But then she had the wherewithal on the last page to say, well, she lives in Florida. She's got some property here. It's not uncommon that people have hunting property here, and they're up here periodically. And she watched it on the TV, and she knows what she knows. There's no evidence there. Mr. Brandt's affidavit is equally unable to establish any of the formidable obstacles he has to establish. And if you look at the case of Stevens versus the Sun News, the Supreme Court talked about what a formidable burden that is. And it was in the context, in that case, they actually used attorney affidavits. They used the senator's affidavit, and it talked about the inability of the Horry County to give a fair and impartial trial to the plaintiff in that case.
So now Mr. Murdaugh's attorney has finally arrived, and we'll get to hear from him on these motions. And unlike the other 2 lawyers who have been a little bit long-winded in terms of their explanations, I've obviously cut this down quite a bit so that it would fit in a decent YouTube video. He is very brief and gets right to the point, and unexpectedly comes to the aid of Mr. Tinsley. Let's watch.
Look, on behalf of Alec Murdaugh, I'd be glad to hear from you.
Thank you. On both motions, on the Motion to transfer venue, Your Honor. Just briefly, his view is that there's really no place in the English-speaking world that you can transfer the case where people haven't heard about it. And reluctantly have to agree with Mr. Tinsley that we're going to have to rely on the integrity of the jury and good voir dire and jury selection to find a panel that can put aside the other things surrounding the Murdaughs and focus just on the facts of this case. So for that reason, we have not joined in that motion to transfer venue. As to the motion to sever, Your Honor, the one interest we have is that we believe that under the Contribution Among Joint Tortfeasors Act, Mr. Murdaugh is entitled to have his liability, if any, reduced by the liability of others. Parker's can't, because their liability arises out of the sale or use of alcohol, and that's one of the exclusions under the Act. But we're going to take the position that that doesn't apply to Mr. Murdaugh, and so it would complicate the trial if you had separate trials with Parker's and Mr. Murdaugh. So for that reason, he opposes the motion to sever.
All right, thank you, Mr. Cook.
So now we know the parties and the positions, and it's going to be up to the judge to decide this matter. So let's listen to how the judge handles the issue of how this case or how this motion is going to come out.
Today, and I've had plenty of time before today, in addition to the oral arguments, to review all the briefs, the rulings I've made in the past, the arguments that were made on the briefs, motions that had been filed in the case. Based upon that, on Greg Parker's second motion to sever, I deny that motion, and Greg Parker's motion to transfer venue, the court denies that motion as well.
Mallory Beach's case is a sad case because a young life, beautiful young woman was lost basically due to the combination of stupidity and alcohol. I've never been particularly good at driving a boat in good weather and bright sunshine. I can only imagine how awful I would be at driving a boat in the middle of the night, you know, tanked up on alcohol. And of course, we don't know for sure what the levels of alcohol were or anything like that now. And of course, the criminal case is gone, so we're not going to know anything more about that. But what I would say is that I think this is going to be a case where the jury is going to come down fairly heavily on Mr. Parker. And as odd as it sounds, they are likely to give Alec Murdaugh a bit of a break here, because although he entrusted the boat to his son, most of us, when we have an 18-year-old son, where we trust them with the family car, why wouldn't we trust them with a boat, particularly if they knew how to operate the boat and had used the boat before? So there will be a lot of defense presented in this case, and in case you're wondering, both Mr. Parker's attorney and Mr. Murdaugh's attorney are probably being paid for by insurance, whereas Mr. Tinsley is representing the plaintiff, the Beaches, on a contingent fee agreement. So if you have any questions, please feel free to leave them in the comments down below. If you would, I'd appreciate a like, a subscribe, and thank you very much for all of you who have emailed me and told me of the many kind things that you have done for other people. I think that I am very blessed to have such a good group of people who watch my channel. So thank you. Have a marvelous day. Come join me down here at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.